Our good friend Ken Miller is here. Ken does a wonderful job with medical malpractice cases, which is a whole different animal than, our car wreck and workers' comp and slip and fall. So kind of tell people what it takes, what you look for, and really just how much different it is in a med mal case than a car wreck case.
Well, I started my law practice doing med mal defense, and now I just represent injured victims of medical malpractice. Makes about 95% of my cases, and they are very, very difficult. The statute of limitations, which is the time to bring a lawsuit, is different. It's minimized. The state came in and passed legislation to protect the physicians, and so prior to even filing a lawsuit, you have to provide a pre-notice, which is a letter, and also have experts involved. But the main difference is going to the expert, where in order to establish your case, you need an expert to establish a standard of care and that the doctor or nurse or healthcare practitioner breach that standard and cause damages. And that just increases the expenses massively to bring a case like that. Most experts will run you a fair amount of money to bring them into Mississippi to testify.
Let me ask, because we've gotten calls like this, and I always kind of wonder, is it a med mal case, is it a premises case? Let's say you've been a patient at XYZ hospital, you're getting discharged. A lot of hospitals are going to roll you out in a wheelchair, and we've had this call. I was getting rolled out in a wheelchair, the front wheel caught in a little, depression in the floor, and I got thrown out of the wheelchair while the nurse assistant was pushing me out. Would that be a premises case? Would that be a medical malpractice case?
I think as an attorney, you should treat it as a malpractice case because of the statute is different. But I have to say it's on a case-by-case basis. We had a recent case that we worked with you all where the lady came out. They didn't have her in a wheelchair, and she fell, and she should have been in a wheelchair. That was I believe that's definitely a medical malpractice case because there was a medical decision. On the other hand, if it's something on the property that actually caused it, it very well could be a premise case.
Yep. And that's the key. I know you talked about the statute's different. It's a 2-year statute on a medical malpractice case versus, a traditional 3-year in a normal auto accident or premises case. Is it 2 years even if you're suing a state hospital or a county hospital, or is that
1 year on a state hospital? But also equally important is you want it as a premise case because your caps are different. Your caps in a med mal case are $500,000 for pain and suffering. However, in a premise case or a car wreck, they're $1 million. Mm-hmm. So you would definitely want to plead it and try to avert it being a med mal case, but it may very well be a medical malpractice case.
So you mentioned when we were talking there was a seismic change in tort reform, I guess, 20 years ago now?
Right. Governor Musgrove.
Yeah. That Governor Musgrove, the last Democrat-elected governor in the state of Mississippi, what really was the driving force behind that tort reform that brought about the $500,000 cap and the fact that you got to give pre-notice and have an expert already retained and so forth?
Well, I was already doing medical malpractice cases at the time, and I remember I was taking a doctor's deposition, and one of the questions I asked were, how many times have you been sued? And he said 35 to 40 times, and I was astounded. I was like, well, what do you mean? And he said, oh, let me explain. It's all because I was from prescribing medications. And so I think what happened is that there was when there was a massive influx of drug lawsuits and they would bring the doctors in, that drove the lawsuit amount. And quite frankly, the doctors just got tired of it. If you remember, there were the white coats walking out on the coast, and different events happened, and it stirred it up, and it became a problem where we thought we would lose a significant portion of our physicians, and that drove tort reform.
And I know that you get the term that Richard's heard, you've heard, I've heard. It's like, oh, you're ambulance chasers. That's not what you're doing. I know that you probably get, for every 100 calls that you get on someone saying, hey, I had a medical malpractice case, the percentage of cases that, A, you end up getting medical records on is ridiculously low. And then even from that percent that you take is low. I think people would be shocked to know that it really is. You end up being a great siphoning, tool to be able to explain to people that no, that wasn't medical malpractice, or that's not a case that would potentially qualify for medical malpractice, that it's a very small percentage of cases that you take, and that really you're just trying to weed out. There's bad lawyers, there's bad doctors, there's bad plumbers, there's bad cooks. At the end of the day, we're human, we're going to make mistakes. Well, let's be held accountable for our mistakes.
Yeah, I would say that based upon my review, we look at about 20, we literally look at around 2,400 cases a year, 200 a month. And out of those cases, we may get records in 20 cases. And out of those 20 cases, we may take 1 to 2 cases. It's normally like 1.25. So in a course of a year, you're literally looking at 16 cases out of 2,400 cases. And that speaks volumes as to how well the the doctors are in Mississippi and healthcare in general. But those cases that we do take, they are serious. They are clear. There's clear liability, and people have suffered true injuries. And it may be a little bit more than that, but that is basically where we stand on the numbers.